there again. All right. Happy to have everybody. YouTube live presentation number 18 out of 20 daily presentations. They're all different. They're all unique. Topic today that we get asked about a lot, just a few housekeeping items. Of course, today we'll talk about what happens when the person who set up a trust dies. And so a lot of confusion out there about that. So just making sure, having a little fun here. Got my microphone. I guess you can hear me okay, see me okay. I like all those commercials where you got people on the Zoom call or whatever, and everybody's figuring out how to use all the technology and all the video stuff. So one thing I'll tell you we're missing today is the joke from Ron. So maybe Ron's not out there, or maybe he ran through his jokes. So Ron's been a regular, maybe every single day. So we miss you, Ron. If you're out there, let us know you're here. Okay. Probably go about 20 or 30 minutes. Got a lot to cover, as I always do. A couple of housekeeping items. Always like to cover maybe a couple of questions that have been posed as comments on my YouTube channel. So a couple of these involving settling estates. Couple of comments from Hannah in response to one of my videos titled Executor Gone Rogue. Another one, Reasons Estates Don't Settle. Hannah's having some problems. Hannah said the executor, personal representative, has not communicated at all with beneficiaries. It's been over 2 years since probate began and about 7 years since death of testator. I think the majority of assets were life insurance policies to the estate and stocks. And then she goes on another comment, similar problem. Personal representative, that's what the executor or administrator is often called, is the one not settling the estate because she benefits the most by keeping all the assets for herself. What would motivate her to settle the estate if she doesn't have to? The system is flawed big time. All right, so again, I don't know the whole backstory, and I'm going to kind of guess as to what the best advice to Hannah should be under these circumstances. But Hannah's in a tough spot, and sounds like you've got an estate where life insurance was payable to the estate had stock. It's been 7 years since the person died, and I guess Hannah is one of the heirs. The executor apparently is not doing their job. What do you do? Well, when you get down to it, if you can't resolve these things amicably, then it's going to be important for Hannah to get some lawyer help and perhaps seek to get the executor removed from office. And so if the executor doesn't do what a normal executor should do, then the people who suffer because of that can request that a judge replace the executor. It's an adversarial proceeding. It's expensive, takes a lot of time, it's a hassle. But when you've got no other recourse and you can't get these matters resolved amicably, then you sometimes have to turn to our court system, lovely, very inefficient, in order to get these matters resolved. So I wish you well. All right, so topic today is the reason I'm doing this topic, and I got to tell you, I'm getting a little kind of upset that my 20-day string here is coming to an end. I was in the middle of the pandemic. I was working from home. I'm like, I got to do something. And, I had client stuff going on a daily basis. But I was like, let me take 30, 45 minutes out of every day, pick 20 different topics, ones that we get asked about a lot. And let me do a YouTube live presentation. And I hadn't done a series of those before. So I said, shoot, I'll just put up the schedule 20 days in a row. No big deal. Well, it was a big deal. And, every one of these requires preparation. I've got my Windex, what do they call it? Teleprompter right here that I get prepared every day of my outline. I want to do a good job because it's going out there on YouTube, and we've been getting a lot of participation in the live chat. By the way, if you've got either some jokes or some estate planning related questions, throw them in there in the live chat. Over 18 days, there hasn't been a question that I haven't attempted to answer in the live chat. Some of it is unrelated to the particular topic of the day. That's okay. The more the merrier. So bring it on. So it's been really good. And I'm kind of not looking forward to it coming to an ending in 2 days. We only have 2 left after today. And so I don't know what I'm going to do. If you got some suggestions, let me know. I may continue it on a somewhat regular basis. So we'll see. But I'm going to miss it. All right. And what I've found is that my goal with this YouTube channel is just to really educate as many people as we can. I know I even personally can't provide legal help to most of the people watching these videos. They're in other states. I can't help them. I don't want to help. I don't want to be their lawyer, and because I can't be their lawyer. But to the extent I can provide you with some guidance, some education, some peace of mind, that's phenomenal for me. All right. So confusion out there about what happens when a trust terminates or ends. I think some people think when a trust ends, all of the trust assets just go into this big trust black hole, never to appear again. And that's just not true. So to get down to what happens upon when a person who sets up a trust dies, or quite frankly, when a trust terminates, we got to just understand the basics of who are the parties to a trust. And so let me describe maybe the 4 different parties to a trust. Some of these can be the same people. So every trust has one or more settlors. That's the people setting up the trust. And generally, that's the people contributing assets to a trust. Every trust has one or more trustees. That's who's in charge of managing and administering the trust assets while the trust is in existence. Then there's going to be also backup trustees, because sometimes these trusts last for many, many years or over multiple lifetimes. So you have to have successors. All trusts have beneficiaries, and there's really 2 types of beneficiaries. There are income beneficiaries. Trust assets often produce income, interest, dividends, rental income. So income beneficiaries in general are entitled to the trust income. And then there are principal beneficiaries of a trust, who's entitled to the trust assets later at trust termination. That's stuff we're going to get into. So every trust has a trust term, or when does the trust end? And you may have to get advice on your particular state rules on how long a trust can last. I'm going to go into some of that, but let me give you some examples of different kinds of trusts and the typical trust terms of not term, but when the trust ends as to the particular type of trust. So very common type of trust, the old typical avoid probate revocable living trust that either an individual or often a married couple establishes they are the settlors, often lasts for the settlor's lifetime. It actually lasts beyond that, because when the settlors die, there's a process for the trust to terminate. And so that trust's existence, it remains at least until the trust assets can be distributed to what is typically the children or grandchildren, or what I call principal beneficiaries of the settlor's revocable living trust. Sometimes people transfer assets to their children in a trust for their children this is the wealthier folks who want to get assets out of their estate to avoid the 40% estate tax. They put assets in a trust for their children. That trust might terminate maybe 1 year after the death of the settlor or settlors, because the estate tax is due 9 months after the death of the settlor or settlors. And so even though the assets in these estate tax avoidance trusts are not subject to the estate tax, those assets are often used to pay the estate tax on the remaining estate assets. And so that tax is due 9 months after the death of the settlor or settlors. So oftentimes settlors set up a trust like that terminates 1 year after the death of the settlor or surviving settlor, so that no assets are dispersed out of that trust until all of the estate tax accounting is done. And then you have the special needs trust that often parents set up for children who have special needs, maybe getting certain government benefits. Those trusts for the special needs child often last until the death of the special needs child. And so the benefit of that trust is the special needs child may be getting certain benefits, certain government benefits, and assets can't be in that special needs child's name, so they're in a special needs trust for the benefit of that child, and so it preserves government benefits. Other parents, especially parents of young children, often in their wills or in their trusts, they set up trusts for their minor children. Parent might say, I have 3 children, they're 6, 4, and 2. If I pass away, I want my life insurance, my retirement accounts, the proceeds of the sale of my house, if my house is sold, and my investments and my money to go into a trust for the benefit of my children. I name my brother as the trustee, and that trust will last until my children reach the age of 25, or it might say that trust may terminate in stages, with my children getting 1/3 of their share at 25, 1/2 of what's left at 30, and the remainder at 35. Those are the termination dates. Sometimes a married person sets up a trust for their spouse. Husband may set up a trust and say, when I die, I want either all or certain of my assets, however specific he wants or needs to be, to go into a trust for the benefit of my spouse. And if my spouse needs those assets for her health, education, maintenance, or support, the trustee may make distributions from that trust to my spouse, but the termination date of that trust will be perhaps when my surviving spouse dies, or maybe when the earlier to occur of my spouse dies or remarries, or sometimes maybe the earlier to occur of my spouse dies or remarries or shacks up with somebody. It's not usually in those terms, but you get the idea. Then that trust terminates and assets would go to the husband's principal beneficiaries that he named in that trust, maybe his children. And then we see some trust, oftentimes trust for the family farm, or the trust for some often piece of property or business interest that the settlor wants to keep in the family for as long as he or she can. They want it to be for the kids. They want it to be for the grandkids. They want it to be for the great-grandkids. So, Alex, looks like you're having trouble connecting to the live presentation. Let me know if you get through. And so they want this trust to last for as long as it can last. And so you'll see some trusts say this trust shall last for the longest term permitted by law. And so then we have to look at, the particular state and see what the maximum term is for a trust in your particular state. And there's these rules against perpetuities. A trust can't last forever. In fact, in my state, in Louisiana, if the beneficiaries are what's called natural persons, and there's other time periods when beneficiaries of trusts are not natural persons, but in most trusts, the beneficiaries are natural persons. And if that's the case, a trust can't last beyond the later of what's called the death of the last surviving income beneficiary, or 20 years after the death of the last settlor to die. The later of those is the longest period of time that a trust can last. So sometimes maybe old grandparents will say, I set up a trust, put my family farm in that trust. My children will be the first income beneficiaries. My grandchildren will be successor income beneficiaries. And my great-grandchildren will be the principal beneficiaries. And so that trust may last, it may last for 60 or 70 years, because the grandchildren may be, 4 years old, and the trust doesn't last until they die, which may be 70, 80, 90 years in the future. All right, so Kurt mentioned, wish you would publish a checklist on your website, what to do when your spouse dies and what to do when your last parent dies, so people could print it off when it happens. Not a bad idea. I probably won't spend the time writing that out, but it is a great idea for, quite frankly, I'm more of a talker than a writer, so Yeah, I could do a video and attach in the description maybe some PDF worksheet or checklist, like you say. Good suggestion, Kurt. Keep them coming. Okay, so what happens when a trust terminates? That's what I want to get to. I just went through, I think, 6 or 7 scenarios on different kinds of trusts and when they terminate. Now I want to go through what happens when a trust terminates. And I will tell you, some trusts are written maybe incorrectly in that they don't provide for a trust termination date. And so our trust code has a provision that says in the absence of a term stipulation, the trust lasts until the death of the last income beneficiary. All right, so let me give an example. Let's say father sets up a trust and he contributes assets to that trust. And in the trust, he names son as the lifetime income beneficiary, and he names grandchild as the principal beneficiary, and perhaps he names son as the first trustee and grandchild as the successor trustee. And he states in that trust that the trust will end, or the trust term will last until grandchild reaches the age of 65. And let's say today, the grandchild is 10 years old. So that trust is going to last for the next 55 years. Assets will likely be in that trust. And as long as son is alive, if those trust assets produce income, they will be distributed to son. And then when son dies, grandchild is the successor income beneficiary. Let's say when son dies, grandchild is 50. So from 50 to 65, grandchild is getting the income off of those trust assets. And then the trust terminates when grandchild reaches the age of 65. And since he's the trustee, he will distribute the assets from the trust to himself. So let's look at different kinds of assets and what those distributions typically look like. All right, so sometimes trusts own cash. They own bank accounts. They own checking accounts, savings accounts, certificates of deposit. So when a trust terminates and assets are to be dispersed to the appropriate, perhaps principal beneficiary, the trustee who has signature authority on trust accounts is to simply distribute the cash assets from the trust account to the beneficiary. Maybe the trustee simply writes a check out of a trust checking account to the beneficiary. So that's simple enough as how assets get dispersed from bank accounts. If the trust owns brokerage accounts or publicly traded stock, sometimes we'll get the question, does the trustee have to sell everything and then just distribute cash to the beneficiary? Well, only if the trust requires that, and rarely do we see a trust require that. So if the trust owns stock, the trustee, who again has signature authority over the brokerage account, merely directs that the assets be transferred from the trust account perhaps to the beneficiary's individual trust account, which the beneficiary may have to establish in order to effect the transfer from the trust to that individual principal beneficiary. What if the trust owns real estate? Very common. Then you probably have to get lawyers or real estate people involved, because if a trust owns a tract of land and the trust is terminating, then the trustee and that beneficiary will have to sign off on the transfer of real estate from the trust to the beneficiary. So there's some kind of deed, or whatever it's appropriately called in your state or in your county or parish, where the trustee will sign conveying the trust's interest in that property from the trust to the principal beneficiary. The trustee will sign that transfer on behalf of the trust. The beneficiary will sign that transfer accepting the property out of the trust into his or her name. And then that transfer typically gets recorded in the land records where in the county or the parish where that property is located, and that's how real estate gets transferred out of a trust to a beneficiary. Now, a few notes on termination of trust, or settlor dies and trust terminates. A lot of people feel like that distribution from the trust is going to be some income taxable event. So, and I'm here to say generally it's not an income taxable event. The rationale is if grandfather were to write a check to you for $15,000, forget trusts for now. Grandfather writes a check to grandson for $15,000 and gives it to him. That's not an income taxable event. Grandfather could write a check for $100,000 to grandson and give it to him, and that's not an income taxable event. Yes, grandfather used some of his estate tax exemption because he made a gift in excess of $15,000, and that's a gift and estate tax matter, but it's still not an income taxable event. I've done a lot of videos on that. So you might start, a gift or an inheritance in general is not an income taxable event to either the donor or the person receiving the gift or the inheritance. So if grandfather gives writes a $100,000 check to his grandson, and that's not, taxable income to the grandson, you can see the rationale there when grandfather puts $100,000 in a trust for grandson to get at some later date. And maybe 10 or 15 years in the future, when grandson gets that distribution, it also is not a taxable event. So what the trust did is it just prolonged the time period within which that beneficiary received the gift. Now, if stuff is put into a trust for grandson to get later, and once it's put into the trust, those assets start to produce some income. That income is going to be subject to income tax to either the trust, which has to file a trust income tax return and pay tax on its trust income, or perhaps that income gets distributed to the beneficiary in a way that the beneficiary simply reports that income on the beneficiary's income tax return. So, but generally, when a trust terminates and assets are distributed from the trust to the principal beneficiary, that's typically not an income taxable event. Another issue that we get questions about often is that going to mean that if a married person gets a distribution from a trust and then years later they get divorced, well, the distribution from the trust to the beneficiary kind of automatically made it owned by both spouses. So if that beneficiary later gets divorced, they lose half of the distribution. Not necessarily the case. So typically, if that was an inheritance in the trust, and then that inheritance is then distributed to the beneficiary, that inheritance, at least for those of us in community property states, that distribution retains its separate property status. Now, once it's out of the trust and it goes to that married beneficiary, if that married beneficiary then commingles that distribution with other community property assets that the couple has, that could render that separate property, it may cause that separate property to become community property, because when separate property and community property get commingled, it all becomes community property generally. So beneficiaries of trust have to be aware of that. And then another issue with a trust distribution is that grandfather who put $100,000 in a trust for his grandson. It's likely going to be what's called a spendthrift trust. If you read the trust, it's going to have some provision in there that says this trust is a spendthrift trust. Just about every trust has that in it, which means that the grandson, he can't use those trust assets as collateral for a loan. If the grandson gets successfully sued and has judgments against him, then generally creditors of the grandson can't seize the grandson's interest in the trust. But however, and it also means that the spendthrift trust also means that the grandson, he can't alienate his interest in the trust. So he can't go to some third party and say, hey, I'm 50 right now, but when I'm 65, I'm entitled to, all of these trust assets, which are now $300,000. Now I'm 50. I want to sell my interest in this trust to you. I want to get some cash now, and then you can have it when I'm 65. Spendthrift restraints prevent a beneficiary from alienating their interest in a trust. So it really just protects things in trust until that beneficiary, under our example, reaches that age of 65. Now, once they're 65 and those assets are dispersed out of the trust to the beneficiaries, all those, trust protections are gone. All of those, spendthrift restraints and all the, beneficiary can do whatever they want to it with it once they get it. So it's often common, or maybe should be common, for settlors to set up trusts for their children, for their grandchildren, and to perhaps err on the side of making that trust last for a longer period than they would have ordinarily suggested, to keep those spendthrift provisions in place, but perhaps give the trustee the discretion to make distributions to the beneficiary if the trustee determines it's appropriate for the beneficiary's health, education, maintenance, and support. Typically, the trustee may be a different person from the beneficiary. So that's just something to consider on how long should you make your trust that you're setting up last. Okay, and I will say sometimes you'll see trusts terminate in stages. Very common when the parent is doing some estate planning, they have young children. They say that when they pass away, they want assets to go in trust. They don't want the children to get it when they're 18. They don't want judges to supervise it in some guardianship proceeding until the children are 18, and then it gets dumped in their lap. All that's a nuisance, all that's a pain, all that's difficult, never works out well. So oftentimes parents of minor children set up their own estate planning so that when they pass away, their assets go in a trust for the benefit of the children. They name a trustee, and of course they're also going to name a guardian, but they name a trustee, and they often provide that those children are to receive the trust assets in stages, or put another way, the trust will terminate in stages. Common scenarios: a third at 25, one half of what's left at 30, the rest at 35. Sometimes you see 25, 35, and 45, 30, 40, and 50, 21, 25, 28. There's no limit on what you can do there. But some parents feel like, well, let's give them some of it. And if they make a mistake and learn from it, they still have more distributions to come. So you see that sometimes. All right, let's see. Trustin said, my parents want their house sold when they die and the proceeds distributed to their children equally. Does the transfer of the trust property to the trust have to occur before the sale? Good question. So it can happen either way. So parents who want to make that when they die sale as easy as possible, parents will also often set up their revocable living trust. They'll actually transfer the house to their trust while the parents are alive, and then they'll name a successor trustee of that trust to handle the trust assets when they die. And if that home is already in the parents' trust when the parents die, then the day after the parents die, that successor trustee, and maybe that's one of the children, can stick that for sale sign in the yard. They have the authority to sell it. They sell the house in the trust. The check at the closing is payable to the trust. That trustee deposits that check in a trust account and then distributes the trust proceeds or the trust account assets to the beneficiaries of that trust. That's one way to do it. The other way to do it is for the parents to leave that home in their name. And then what happens is when the parents die, there needs to be a probate proceeding because the title of that home will be frozen. So the children or the executor named in the will, if there was a will have to go through some court and attorney involvement to either get an executor confirmed and then go through the process of selling the house after that takes place, or going through the court process of having the house formally transferred to the children's name so they can sell it. That typically takes months to go through that court process. So it's often easier when the parents put it in the trust ahead of time. I hope that answers your question. If not, give me some follow-up. Johnny asked a question, can an irrevocable trust, IRT, be set up to end after a period of years after the grantor passes? It certainly can. And so oftentimes, let me give an example. I don't know if this is what you're referring to, but parents will often, older parents, 60s, 70s, will put their assets in an irrevocable trust, perhaps to get assets out of their name for purposes of long-term care Medicaid eligibility, which, by the way, is the topic of tomorrow's YouTube live presentation. And sometimes parents will say, that trust needs to be in effect as long as we live, but when we die, the trust terminates and assets get dispersed. Sometimes parents might say, no, we want to set up this trust so it continues on after we die. For some reason, they didn't want the trust assets dispersed upon their death. Maybe children responsibility issues, maybe son-in-law, daughter-in-law issues that would have influence over their children if the children did receive the assets immediately. So anyway, to answer your question, great question, Johnny. Yes, it can last, at least in my state, for until 20 years after the last settlor dies or the death of the last surviving income beneficiary. So many parents set up trusts where their children are the income beneficiaries of that trust, or at least they're the successor income beneficiaries. So really parents can set up an irrevocable trust that would last at least for their children's lives, and if not, 20 years beyond that. So there you go, little trust termination question there. Good question, Johnny. Hope I answered your question. If not, bring it on some more. Okay, so big one tomorrow. If you know anybody who has the least bit of concern, maybe you have parents, maybe you have cousins or friends, and maybe you know that they should be concerned about if they have to go into a nursing home in the future. We're seeing messes with nursing homes on our televisions in the last few months. Not so much in the last few weeks, because maybe they've got it under control. But there was a several-week period where, nursing homes were like the devil. And because so many people were getting coronavirus, so many people were dying, I was thinking to myself, how in the world will anybody ever go to a nursing home in the future? That seems to have died down. Terrible, no pun intended. And seems like maybe assisted living facilities and nursing homes will take corrective action from a health standpoint, from a cleanliness standpoint. Let's hope so. And so make those facilities safe into the future. So if you know anybody who's worried about losing their life savings, losing their home in the event they need long-term care in the future, because it's like half of our population in America, half of 65-year-olds, something like that, will need long-term care in the future. And that long-term care, as you might imagine, is the cost of it is going to increase higher than the cost of inflation. Tomorrow is all about what people can do to protect what they have here in 2020 so that they can but structure them in a way where the government isn't going to require that they deplete everything they own if they get sick. It's probably the biggest of the 20 YouTube presentations that I'm going to be giving on this morning, but I'm happy that you're on. See, that's part of my humor that I just give away for free. How easy or complicated is to update trusts when grantor moves to another state when underlying assets are the same? Often it's not necessary to update trusts when a grantor moves to another state and even intends to stay there permanently. So most trusts, they're kind of designed to work wherever you are. But I always do suggest, because it's worth it, if you set up a trust in one state and then you move to another state and you plan to stay in that new state permanently, then seek out somebody like me in that new state. Bring your documentation to them. Tell them what your concerns are, if you even have any concerns. And maybe your concern is, I just moved to this state. I want to make sure that I'm good with what I got. Here's what I got. I did this in my old state. And let them review it. Maybe they'll tell you, you're good based on your circumstances and my review of the documentation. You're good. Nothing needs to change. Everything's still effective. Maybe they'll tell you that, or maybe they'll tell you, our state has some nuances. I see some things in the documentation that you've provided with me. In the long-term scheme of things, it may be appropriate for us to amend this or amend that to better comply with this new state's rules and regulations. Maybe we should do this amendment. So you're not necessarily starting over, but perhaps you're doing some amendment. Hope that helps. So bottom line there, happy me if you do set up something, a trust in one state, move to another state, have it reviewed, may be good, may require some amendment. All right, we had a blaze of live chat just in the last few minutes, all outstanding questions for 18 consecutive days. The questions have been really top notch, really some good contributions there. So only 2 of these left. Certainly inviting you to jump on those. I'm going to be kind of disappointed when it's over with in a couple of days. That'll be on Thursday, but who knows? Maybe I'll do some bonus ones. Haven't even thought of it yet. Big one tomorrow on the whole Medicaid eligibility planning in the year 2020. What's hot? What's new? What are people doing? Spread the word. I'll put the link on my YouTube channel in the community section, Rabelais Estate Planning LLC. Look in the community section. The link will be there. I'll put it on LinkedIn as well. Share that link with everybody you know. That's the one favor I'm asking, in addition to clicking the like button and the subscription button, so YouTube will show my video to more people. Okay, top-notch questions and top-notch answered. You got that right, David. This has been some really good stuff. All right, look forward to seeing you tomorrow. Y'all have a great day. See you then.